The doctrine of foreign equivalence. What the heck does that mean? Hi, I'm Derek Fahey. I'm a registered patent attorney and a trademark attorney with the Plus IP firm. And this is going to be a short video on the doctrine of foreign equivalence and how you can actually get around office actions that discuss or raise the doctrine of foreign equivalence. If you're watching this video, you've probably filed an application and are facing this particular rejection, or you're an attorney and you were facing this rejection for the first time and you're wondering what you can do. Well, rest assured, I'm going to give you some answers here that will hopefully help you. So first off, let's back up. Let's say you file an application for gato negro, let's call it black cat for lamps. And you file an application, you wait the time period to get a response from the examining attorney, and you get a response after the examining attorney examines the application, a likelihood of confusion rejection. You get an office action stating that your mark, Black Cat, is rejected based upon a prior filed application or registration for Black Cat for lamps. Now, you may be asking yourself, well, what do I do? Well, let's talk about what the rejection is. The rejection basically says that a consumer would likely be confused because they would stop and translate Black Cat and understand that gato negro, which is which is the Spanish equivalent of black cat, means the same, and therefore consumers are likely to be confused. All right, so that's the first thing. Now, what can you do? Okay, now that applies both ways. So if it was black cat and the registered mark was gato negro, same thing as if you were filing for gato negro and the actual mark was black cat. Okay, there's two main ways you can try to get out of these rejections, and it depends on how your application's filed. But the first one is if the word is not a direct and literal translation. So if the word is not a direct and literal translation, what does that mean? Well, if you Google the word, it has more than one meaning. So for example, paloma in Spanish is the actual Spanish word for both dove and also pigeon. So it's not a direct and literal translation. There's two different meanings to it. So for example, if you do a search on Google or look up in the dictionary and there's more than one meaning, more than one literal translation, then you can argue that because there's more than one direct or literal translation, that the doctrine of foreign equivalence should not apply in this case, and the examining attorney should not have applied that doctrine, and therefore you actually should be allowed to register the mark, and the rejection should be withdrawn. That's the first way of doing it. It's a really good option. Try to find some other meanings besides the exact meaning that was cited against you. The second way is you can argue that the language that you're using is a dead or obscure language. So I'm going to drop a link into this chat, or in the comments you'll see a link, and that particular link takes you to how often or how many people in the United States speak the particular language. So if the word is a translation of Spanish, that's going to be a really difficult argument to make because a lot of people speak Spanish in the United States. But if you're talking about some very, almost dead or very small amount of people actually speak the language in the United States, like a small amount of people speak a very unknown or not well-known Polynesian language, that's going to be difficult for the examining attorney to argue that the ordinary U.S. consumer can speak the language. So that's the second way you can try to get around it. In the response to the office action, you can also argue the other factors for likelihood of confusion. You can argue that the word is widely used in the marketplace. You can argue that how maybe the word is descriptive and not entitled to broad protection. But if you're dealing with the doctrine of foreign equivalence, what you need to do is try to argue, like I said, number one, there's multiple meanings, so there's no direct and literal translation, so that should not be applied. And number two, that potentially the argument that the language is dead or obscure. Two great ways to potentially get out of a likelihood of confusion or rejection based on the doctrine of foreign equivalence. I hope you found this video helpful. My name is Derek Fahey. You can you can email me at derek@plusfirm.com, PLUDEREK@PLUSFIRM.com. You can also find me on social media on TikTok or Instagram at Derek Fahey PA, DEREKFAHEYPA, or find us online. My YouTube channel is Derek Fahey ESQ, DEREKFAHEYESQ. Looking forward to helping you, and good luck with that response to a likelihood of confusion rejection based on the doctrine of foreign equivalence.